Welcome to UPSC Vinoth. So today we are going to discuss polity. In polity, one of the most important topic it is judiciary. Every year you will get a question with respect to judiciary. And today we are going to discuss one of the important topic, that is judge challenges Supreme Court probe. So judge itself challenging Supreme Court probe. What is the issue? A former Supreme Court judge, former Supreme Court CJI actions in the cash case and parliamentary procedure for removal of judge. So why it is in the news? What all this is about? Allahabad High Court Judge Justice Yashwant Verma said that Supreme Court in-house inquiry process is parallel extra-constitutional mechanism. He quotes that that is Supreme Court's in-house inquiry process is a parallel extra-constitutional mechanism designed for judiciary to assert Parliament's exclusive authority. Okay, so this is the news. So with respect to this, we are going to discuss the process and procedure to remove the judge under Judges Enquiry Act. See, first PYQ is judges process of removal of judges comes under Judges Enquiry Act 1968. Yes, it comes under Judges Enquiry Act 1968. Okay, so first of all, what is the procedures to remove the judge? First, initiation of motion. So see, look at this point. This is very important for the PYQ. Initiation of motion. So initiation requires a motion to initiate. That motion must be signed by at least 100 Lok Sabha. See the count: 100 Lok Sabha MPs or 50 Rajya Sabha MPs. 100 Lok Sabha MPs or 50 Rajya Sabha MPs. After signing the motion, it is placed under, if it is Lok Sabha, it is placed under Speaker. If it is Rajya Sabha, it is placed under Chairman. Now, after the motion is submitted to the Speaker or Chairman, second step, so admittance and inquiry committee. So admittance and inquiry committee. So if the motion is admitted, the presiding officer constitutes three-member inquiry committee. That is Supreme Court judge, a Chief Justice of High Court, and a distinguished jurist. So the committee to investigate charges on the judge who is going to be removed, or else whom the motion is addressing. Now the committee will submit a report. If the committee finds judges guilty, the motion of removal can be taken to Parliament for voting. See, after the committee's report, if the judge is found guilty, then it is moved to Parliament. Then it is put under Parliament approval. The motion must be passed by each house of the Parliament. Each house of the Parliament by the majority of total membership and by the majority of not less than 2/3 of members present and voting. That means special majority. By both the houses. Special majority by both the houses. And after the Parliament passing, now it comes under President's approval. After motion passed by the Parliament, both the houses, the President issue an order of removal. This is procedure to remove of judges under a Judges Enquiry Act. Now, Supreme Court in-house inquiry mechanism. So this is in-house inquiry mechanism. So to make the judges, to make whom they are probing to move against the motion. Okay, the process was submitted by Justice K.H. Keher. Okay, Justice K.H. Keher. So, and Arun Mishra. Justice K.H. Keher and Arun Mishra, they framed a 7 steps process. Complaint received by, first complaint received by whom? So, by Chief Justice of High Court, or else Chief Justice of India, or else President. the complaint is received by any three of this member. Then preliminary review by CJA. The complaint is reviewed by CJA. A preliminary report from CJA is taken. If CJA has a power to decide whether it is serious issue or not serious issue. If he feels it is not serious, he can drop the issue there itself. If he feels the issue is serious against the judge, then he seeks the report from Chief Justice of High Court, concerned High Court. So now, if then after if the issue is serious, so then CJA may get statement from accused judge. He calls the accused judge and he gets the statement from the accused judge. And after that, and form a three-member inquiry committee. Two High Court judges and two High Court Chief Justice, two High Court Chief Justice and one High Court judges. They will inquire and submit the report to CJA. Again, it's based on CJA. If the CJA feels it is not serious, if the CJA feels it is not serious, it comes under CJA's advice. So if the allegation is not serious against the judge, CJA may advise and the judge place the report on record. If it is serious, CJA may advise judge to resign or retire voluntarily. CJA may advise the judge to resign or retire voluntarily. If the concerned judge refuses to resign or retire voluntarily, CJA will directly concern the High Court judge and ask him not to assign any judicial work. So, and ask him not to assign any judicial work. See, this is the Judges Removal and Inquiry Act. Now, see, Parliament procedure, initiation of motion, admit and inquiry, committee investigation, committee report, Parliament approval, President order. An in-house inquiry, complaint received by CJI, High Court or CJI or President, preliminary assessment, inquiry committee is set up, then inquiry is processed, committee reports find, if finding is serious to be guilty, if it is serious crime, then charges is substantiated. If it is not serious, judges are advised. So finally, CJI will advise the judges to resign or retire. If the judges refuse to resign or retire, CJI can ask a court to stop the cases for stop assigning the work. Oh, okay. So now see, this is in-house proceedings. This is parliamentary proceedings. You should understand these two are different. First, in-house proceedings takes place. After, if in-house proceedings is failed to bring out the outcome, then parliamentary procedure of removal of judges takes place. See, listen carefully. There are multiple number of PYQs, and also if you follow this PYQ, it is, you know that you can come to know that the PYQs are getting repeated. First thing, 2014. The motion of impeachment of judge of Supreme Court in India must be signed by at least 100 members of Lok Sabha. Yes. And the motion to impeach the judge of Supreme Court in India must be signed by at least 50 members of Rajya Sabha. Yes, both 1 and 2 are correct. Next, 2019. The President of India can remove the judge of Supreme Court on the recommendation of Parliament. Yes, the President of India can remove the judge of Supreme Court on the recommendation of Parliament. The procedure to removal of judges of Supreme Court in India is regulated by Act of Parliament. Yes, both are correct. Again, both are correct. And see, both are correct. Then PYQ number 3. See, judges of Supreme Court can be removed only on the grounds of proven misbehavior and capacity. Yes, this is, even though you can say that, sir, only seems to be extreme statement, but according to the Judges Inquiry Act, a judge of Supreme Court can be removed only on the grounds of proven misbehavior or incapacity. Yes, statement 1 is correct. The removal requires a special majority of both the House of Parliament. Yes, the removal of judge requires special majority in both the houses. The Chief Justice of India plays a formal role in removal process. No, Parliament and President plays a formal role in removal process. So 3 is wrong, 1 and 2 is correct. Now, coming up with the next question. See, The motion to impeach the judge of Supreme Court in India cannot be rejected by the speaker. See, the speaker may admit or reject the motion, may or reject the motion. So statement 1 is wrong. If you feel the statement 1 is wrong, then automatically 3 and 4. 3 or 3 and 4. See, let us see what is, we know that statement 2 is wrong. Let us see. The Constitution of India defines. Nowhere Constitution of India defines. Nowhere Constitution of India defines. Okay, the detailed process of impeachment of judges of Supreme Court is given under Judges Inquiry Act. Yes, this is correct. If the motion of impeachment of judges taken up to the voting, the law requires motion to be backed by each house of the parliament and supported by the majority of the total membership. Yes, not less than 2/3 of the, this is special majority. Yes, it is special majority. 3 and 4, just we had discussed. 3 and 4 is correct. 3 and 4 is correct. Again, see, 2023. The motion of removal of judges of Supreme Court must be signed by at least 50 members of Lok Sabha or Rajya Sabha. See, we know that it requires 100 members of Lok Sabha or 50 members of Rajya Sabha. See, the same thing has been repeated with slight modification. The 2024, it was asked in 2024 that this PYQ, and this exactly repeated with slight modification. A person can directly file a petition. A person can directly file a petition on the High Court in the case infringement of fundamental right. Yes, you know that. Yes, you know that it is then so it is called fundamental right. So a person can directly file a petition on High Court in case of infringement of fundamental right. See, it's statement 2 under Article 226. 226, he can directly file a case on High Court. Okay. Now, let us have some model MCQs discussion with respect to above topic. So, while with reference to removal of judges for High Court or Supreme Court of India, consider the following statement. The Constitution of India provides the motion for removal of judges must be signed at least 100 members in the case of Lok Sabha, 50 members in the case of Rajya Sabha. Yes, statement 1 is correct. Under the Judges Inquiry Act 1968, it is mentioned. But the Judges Inquiry Act mandates the constitution of 3-member committee includes the Supreme Court judge and Chief Justice of High Court and distinguished jurisdicts to inquire the charges. Yes, we just saw that, just discussed this. Okay, now statement number 3. The Supreme Court in-house mechanism is formal statutory process defined under Judges Inquiry Act. See, the in-house inquiry mechanism is self-evolved judiciary procedure. It is self-evolved judiciary procedure. Self-evolved judiciary procedure. So statement 3 is wrong. A judge can be removed by the president only after addressed by parliament has been supposed by simple majority. You know that 2/3 majority present and voting. 2/3 special majority. See how I framed the question. Special majority. So you see 3 and only 2 is correct. Statement 1 is incorrect. You know that. Statement 2, statement 3 and statement 4. Okay, see, this is how we should recall the points. Okay, now coming to the next important topic, that is judicial activism and judicial overreach. See, Supreme Court has fixed, why it is in the news, Supreme Court has fixed a time limit for the governor for bill passing. See, this seems to be better at one side, but it comes when judiciary involving in executive, then we can consider as judicial activism and judicial overreach. So, Supreme Court fixes the time limit for the governor for bill passing by state legislature and also ruled that president out to seek opinion if governor reserves the bill, claiming it is unconstitutional under Article 143. President out to seek opinion if the governor reserves the bill, claiming it is unconstitutional under Article 143. See, now we shall discuss. So one of the most important point and which is the most expected question with respect to, already we got a question last year with respect to governor and the bills. Now it is also, so when the Supreme Court involved directly in this case and said that we will pass the bill if the governor is not ready to give assent to the bill, we will pass the bill. The Supreme Court said that. So it seems to be judicial activism. So what is meant by judicial activism? Proactive role played by judiciary to uphold the rights, deliver justice, and ensure constitutional governance, especially in the case of executive or legislative inaction. Inaction. See the word. When the executive or legislative fail to act on their own way, judiciary will come into the case and they will uphold the right and deliver justice, ensure constitutional governance. So the constitutional bias is rooted in judicial review and expanded through interpretation of Article 142. Article 142 is one of the most important article with respect to judiciary. It gives ultimate authority to the judiciary to provide complete justice. So Article 142 has been used by judiciary to to suggest to pass the bill. Okay, now, so previous cases, Visaga vs. State of Rajasthan case 1997 laid down the guidelines against sexual harassment at workplace. So Visaga guidelines, you know that Visaga guidelines. So judiciary has been involved. Okay, then MC Mehta case, environmental activism through PILs. See, these two are game changer cases. These two are landmark and game changer cases. Now let us see what is judicial overreach. See, right now we have discussed what is judicial activism, and now we will see what is judicial overreach. So judicial overreach, when the judiciary crosses the constitutional limit and infringement upon the domain. See, now it is crossing the limit. See, whenever we are talking about judicial activism, it is involving to uphold the rights, deliver justice. But when we use the word judicial overreach, it crossing the limit. See the keyword concern, violation of separation of power. It is basic structure doctrine. So violation of basic structure doctrine. So SE bans firecrackers during Diwali. So Arjun Gopal case criticized for entering the domain of policy making. See, they can ask a government to make. See, Supreme Court must ask a government, Delhi government, to ban crackers and make rules. But instead of asking to the government, they directly involved in ban crackers. And also see, in Delhi Supreme Court as judicial as a best example for judicial overreach. In with respect to banning all the vehicles and banning the vehicles which does not have the pollution clearance certificate. It was done by Supreme Court. That also seems to be judicial activism, and again with the same concept, that was done to control pollution, and with the same concept to control pollution, banning on crackers directly is also seems to be judicial overreach. National anthem in order, mandate playing national anthem in cinema halls, it also seems to be it is executive order. See, who issues order? Executive issues order. Who make policies? So see, legislative make policies. So these two jobs are taken by judiciary. Now it is judicial overreach. So let us discuss all PYQs with respect to judicial activism and judicial overreach, and we can discuss some of the model MCQs also. See, which of the followings are most likely the consequence of judicial activism? Expansion of rights of citizen. Yes. Weakening the executive accountability. See, judicial activism is not weakening the executive accountability, but judicial overreach, if they replace the word with judicial overreach, then it is weakening the executive accountability. Then if the 2 is wrong, automatically 1 and 3 is correct. Strengthen the rule of law. 2012. With the reference to Indian judiciary, consider the following statement. The Constitution of India defines. Where the Constitution of India will define. So the judiciary has power to strike down the laws that violates the Constitution. Yes, 2 is correct. You know that. So question number 3, 2019 PYQ. The Supreme Court of India can entertain public interest litigation. Yes, Supreme Court India can entertain. PIL is a part of basic structure. See, PIL is an innovation. It is not a part of basic structure. It is an innovation. It is a major tool of judicial activism. So, it is not a part of basic structure. Statement 1 is only correct. Now, with the judicial review, see here, 2020, judicial activism. 2017 judicial review. So judicial review, the power of judiciary to examine the constitutionality of legislative enactment. So this is correct. Okay. So 2012, see how many questions we are getting with respect to this judiciary review. Judiciary. With reference to Indian judiciary, consider the following statement. The Constitution of India defines and declares the separation of, see, the Constitution of India defines and declares nowhere. The judiciary has power to strike down the laws. Yes, it is correct. So we already discussed this statement. Okay. 2015, the power of Supreme Court in India to decide disputed case between center and state falls under which jurisdiction? Original jurisdiction. See, it is when there is an issue between center and the state, it comes under original jurisdiction. It comes under original jurisdiction. See, okay. Which one of the following is not a feature of Indian Constitution? So, see, it is very easy. Presidential form of government. And 2020. So, see, which of the following is most likely the consequence of judicial activism? See how many questions with respect to judicial, exact keyword itself. It's not indirect or this direct question. Direct questions. Sorry, we already discussed this question. Okay, fine. Okay, with reference to Indian Constitution, consider the following statement. Consider the following statement. A bill pending in Lok Sabha. A bill pending in Lok Sabha lapses on its dissolution. Yes. A bill pending in Lok Sabha lapses on its dissolution. If the Lok Sabha dissolves, then the bill pending in Lok Sabha will also dissolve. A bill passed by Lok Sabha and pending in Rajya Sabha lapses on dissolution of Lok Sabha. Yes. A bill passed by Lok Sabha pending in Rajya Sabha, if the Lok Sabha dissolves, the bill also fails. A bill passed by both houses of the parliament and pending assent of the president does not lapses. Yes. 1, 2, and 3 all are correct. Okay. So let us discuss now, coming to the expected prelims portion on the basis of above current affair topic. Judicial activism is explicitly mentioned in the Constitution. Nowhere. So when you remove one, directly you will get the answer. Article 142 empowers Supreme Court to pass any order. Yes, any order, though it seems to be extreme. Article 144 is ultimate. See, I use the one word ultimate power to Supreme Court. Judicial overreach may violate the principle of separation of power. Yes, 2 and 3 are correct. Again, with reference to Indian judiciary, concept of judicial activism and overreach, consider the following statement. Judicial activism is a philosophy that it's a philosophy that encourages judges to depart from strict adherence to judicial precedents in favor of progressive and social policies. See, it seems to be great thing. What is judicial activism? Why they are looking for judicial activism? For proactive and to ensure the constitutional governance. So see, this is in Visaga guidelines also. Yes, see, Visaga guidelines, Supreme Court, they voluntarily came up with Visaga guidelines to stop the sexual harassment in working place. So statement 1 is correct. Statement 2, the concept of judicial review, which is formed basis of activism, is explicitly defined in Article 13. Nowhere it is defined. Article 142 empowers Supreme Court to pass. See, Article 142 is ultimate power. Pass any degree or order doing complete justice. Yes, complete justice. Judicial overreach. Judicial overreach is considered as violation of separation of power, which is part of basic structure doctrine. Yes. Finally, only 3 is correct. See, this is how we are framing the question. So next, with regarding to contempt of court. So let us discuss this in next video. The contempt of court. Thank you.